Hello and welcome back to another episode of Careers in Crypto. My name is Sophie and my co-host is Nikita. This week we were very lucky to have two legal experts on the podcast. We talked relationship property and how one can protect their assets, particularly their crypto assets, in a relationship like a marriage or a de facto relationship. We also talked more about the FTX crash, including which jurisdiction the cases may be heard in and how long it may take for the litigation to play out. So without further ado, please let me introduce our guests for this week. First, we have Kesia Denhardt, who's a family law partner at Stace Hammond. She gained an LLB and BA in social science at the University of Otago. Kesia has practiced family law exclusively since 2009 and handles a broad array of matters, including ones involving parenting and guardianship disputes, domestic violence, relationship property and financial support, adoption, surrogacy and embryo donation, paternity issues, Family Protection Act claims, and applications under the Protection of Personal and Property Rights Act. Kesia has written and presented seminars on various family law issues, written articles for various publications, and has been called upon by the media to comment on such issues. Kesia is a member of the Auckland Women Lawyers Association Committee and is an ambassador of White Ribbon New Zealand in recognition of her work with victims of domestic violence. Kesia is also a member of the New Zealand Law Society Standards Committee. Next, we have James Cochrane, who's a partner at the law firm Lane Neve. James holds a Bachelor's and Master's of Laws from the University of Auckland. James specialises in commercial disputes, with particular expertise in banking and finance, insolvency, insurance, company law, and franchise law. James has a passion for crypto and Web3 and is a member of the Blockchain New Zealand Legal Working Group. James gives advice to practitioners and business owners in relation to digital assets, both advisory and contentious, including insolvency practitioners, private wealth clients regarding tax, asset acquisition, structuring, protection, and property transfer. James also advises gaming businesses and other clients in relation to crypto mining, capital raising, DAOs, and the broader regulatory landscape. Oh, welcome, James and Kesia. Thank you so much for joining us.
Thanks for having us.
So we're just going to get started with some little intro questions. So what are your thoughts on owning crypto?
Well, I think James is best placed to speak to that, seeing as he is an owner of crypto. So I'll leave that to James.
Well, I think it's a good idea. I'm really bullish on the subject matter, but I'm conscious that not all cryptos are created equally. So you need to do some due diligence about what you're looking to own.
And why don't you own crypto?
It's a great question, one that I have not prepared to answer, I must be honest. Look, I'm quite risk averse, and for that reason, if I was to invest, and I'm not a big investment person to be perfectly honest, but if I was to, I would be looking to invest in something that was probably a bit more reliable. And I know we're going to talk about this later on, but because crypto and some digital assets more generally are volatile, it does carry a lot of risk. And so that's the predominant reason I think why I haven't sort of gone down that path.
Right.
Kes does technically own an NFT called a Blockstar on the Solana blockchain.
That's right.
I just happen to hold that for her as a bare trustee.
He would know far better what to do with it than I ever would. So that I'm very happy with that. But yes, I've forgotten about that. That's right.
Yeah.
Do you have it displayed, Kesia?
I don't, but you know what, Sophie, I should. And that's a failing on my part, which I will seek to rectify immediately.
Well, if you go and look for an ADLS presentation called Demystifying Digital Assets that Kesia and I did, you'll be able to see Kesia's Blockstar there. It's a good little representation of her. Pink jacket on her.
That's awesome.
Yeah, no, they're really cool. James did a great job at organising that. It was actually a lot of fun. Yeah.
Awesome. Is it a bespoke piece?
It's a so the block stars are from a game. Well, like the NFTs, which are intended to be used in a blockchain game where you are like a band manager, where you train up your NFT to, be a better band. Yeah.
It's kind of like modern SingStar.
Correct. Yeah. So you don't do any singing. Yeah.
Oh, that's awesome. So, James, we know you handle matters relating specifically to crypto. So we'd love to know what your life is like as a crypto lawyer and what are some of the pros and cons that you find in your work.
Yeah. So I'm low-key obsessed with this topic. You asked me, what are my thoughts on owning cryptocurrency? I was a bit coy with that response, but yeah.
I'd definitely dispute that low-key bit, girls, but anyway.
So yeah, I've been interested in this topic for basically since about 2016, and I'm quite interested in macroeconomics and investing, and I heard on the podcast that I listened to them increasingly talking about Bitcoin as an investment, and I found it really interesting. I dipped my toes into the market in around 2018, which happened to be the peak of the last bull market, and the investment promptly went down 90%. I was interested in this thing called Ethereum. Yeah, so that gave me some perspective on crypto as an investment. One of the things that I was taught very early on is you must be prepared in this space for any investment to go to zero. So unless you're willing to take risk, don't invest anything that you're not willing to lose. And I became really interested in it from a legal perspective because of my background is in financial services law. I specialize in advising particularly insolvency practitioners, and there have been a number of big insolvencies in the crypto space, and these happen because crypto is very volatile, and they go through these market cycles of massive booms and massive crashes. And so there's been some big crypto insolvencies like Mt. Gox, and now FTX is the latest one, where these big exchanges blow up and it causes havoc throughout the community. So I was in New Zealand. We've had a couple of significant crypto insolvencies. One's called Bitcoinica, and the other one is called Cryptopia. Cryptopia is probably the most well known. And there's a leading case on Cryptopia on whether crypto can be property and the subject matter for trust. So I was really keen to understand how crypto worked in case one of my clients, insolvency clients, got appointed as an insolvency practitioner to a failed crypto business. And essentially just orange pilled myself. I decided to invest in some crypto and really understand how it all works. What are the different ways you can buy it? Why is it risky to hold crypto, and particularly risky on some exchanges but not others? And why is self-custody so important? And I guess on that journey, I found it a bit like learning a new language, right? You go down these rabbit holes because it's such a wildly fascinating topic. I pretty much read every book I could on the topic. Internet of Money by Andreas Antonopoulos is a great one. There's a really good page turner called Bitcoin Billionaires, which is about the Winklevoss twins. When they separated from Mark Zuckerberg and Facebook. That's really fascinating because they made they were big early investors in Bitcoin. And so I guess because I had this mild obsession with the topic and just talked about it a lot, I started to really, so that I could understand it better, I started writing articles about it for work. Why does a crypto exchange go bust, and what to do? Why is what happens in terms of tax liability if you're trading assets and things like that. So as I wrote more about it and thought about how New Zealand law could apply, I guess that's where my practice has developed. And now, more recently, I've got a whole range of crypto-related clients, Some are, I guess, what you'd call advisory or non-contentious. So we've got clients who are like developers who are wanting to launch NFTs. They might want to understand what's their risk in doing so in terms of financial markets and financial services providers, anti-money laundering, that sort of stuff. They might want advice on structuring, how they structure their businesses. We have clients who are involved in the gaming Web3 sector who, they're also wanting to understand if they've got any regulatory risk. Crypto mining clients who are interested in doing mining, they want to understand what are, I guess, the regulatory headwinds they might face. And we've got private clients who want to know about their possible tax exposure. They want to know about their estate planning. How do we, I guess that was one consideration for me. So if I get hit by a bus, how do I make sure that the assets that I do hold get to my family? And so as you think about these things, it balloons, and I guess is it the right time or the wrong time? It's the right time for me in terms of, a bull market, because there's massive interest in the topic. It's also, I guess, being an insolvency lawyer, I view it as very exciting in a bear market as well, because there's a lot more of crypto-related insolvency because of that. And so, in this period, you also do more contentious or litigious work, like, clients get money stuck on an exchange and then they can't complete a property purchase, in the real world, or they believe their account's been hacked on an exchange and they want you to try and help them get their money back. And of course, there's crypto insolvencies as well. So for me, really exciting. I really enjoy. It's an area that I'm passionate about, and so I love talking about it and doing the law in this area.
And do you find that because you were sort of an early mover, that you have like a huge career advantage by understanding crypto?
I guess that remains to be seen. I mean, is crypto dead? I don't know. I definitely don't think it is. I think it's just going to get, we'll have people will get through this current FTX collapse, and they'll recognise that the technology is here to stay. FTX is like an anomaly for me, right? It's a guy who is, individual actors committing fraud. It's not a failure of the technology. No one's hacked the Bitcoin blockchain ever. The tech hasn't failed. The DeFi protocols, they haven't skipped a beat. This is just a bad actor doing bad things, and it's more like an Enron or an Elizabeth Holmes from Theranos type scenario, right? There's the industry will recover. Yep, sure, there are going to be some people who are really gun shy. There's definitely going to be more regulation because of it, and that might slow adoption. Really depends on whether or not they overregulate. If they overregulate, that'll slow things down for the market. But if they have a favourable regulatory environment and focus on the opportunity here in terms of jobs and tax revenue and things like that, then it'll kick off again in terms of adoption. I think does this give me an advantage? I think the fact that I'm totally obsessed with it, I'm now contradicting myself saying I was low-key obsessed. I am totally obsessed with it. Maybe that obsession means that I am reading about it all the time and learning and trying to follow it. And in a space like this where it moves so rapidly and everything happens in real time and plays out on Twitter, maybe that is an advantage for me over other lawyers who, just pick it up because it's the fad thing to do, I guess it's probably a combination of, am I early? I'm not particularly early compared to some people. There's some people who are in there since 2010, 11. I think probably a combination of those two things, being early but also being passionate.
And I suppose another advantage to being early is you kind of come, well, I don't know if it's an advantage or a disadvantage, is that you come in before a lot of regulations have kind of hit the ground in New Zealand. And do you think that a lack of regulation here makes your job easier or harder, or a bit of both?
I think it's a good question, Sophie. I mean, like, it's when you have grey area in the law and how it's going to be applied, that's really fertile ground for lawyers. And it's not necessarily the case that there's a lack of regulation in New Zealand. I think there's actually quite a lot of regulation that applies to particularly New Zealand businesses operating in this space, and to like New Zealand market participants. We've got a whole range of laws that apply, even though we don't have one specific crypto law. We've still got lots of laws that can apply. The perception that it's not regulated might, probably comes, is more applicable in terms of, for example, businesses like FTX, which were based or headquartered in the Bahamas, but are not subject to as much regulation or regulatory scrutiny as businesses that, for example, are based in the US, where I guess there's an argument to be made that businesses there are not necessarily under that much scrutiny either, but they undoubtedly will be.
So obviously New Zealand has a regulatory landscape that can apply, but we haven't seen a lot of litigation for crypto. I know you mentioned Rusco and Cryptopia earlier, but why do you think New Zealand hasn't seen a lot of litigation specifically, and when do you think that will start to increase here?
Yeah, I think it's because it's still a very young industry, right? In New Zealand, there are some really sizable crypto Web3 projects that are generating huge amounts of revenue, and but they're a lot of probably the reason that there hasn't been that many cases is because it's still really new technology and it hasn't been widely adopted in New Zealand. I think there's read a statistic, I think it was about 7% of New Zealanders held crypto. So it's still pretty new. Businesses are just learning about the tech. I mean, the NFT boom in the last couple of years has been, I think, pretty huge for mainstream adoption. You've got big brands like Prada and Gucci and Nike having their own metaverse, and you've got famous artists like Damien Hirst launching NFT collections. You're seeing mainstream adoption of this technology. And as there's more adoption from these bigger entities, there will be more confidence for smaller players to also have a go. And also, I think there's probably a big component where the regulators in New Zealand are still learning, trying to understand and educate themselves. Our politicians are the same, our lawyers are the same, accountants the same, really trying to understand what's going on. And maybe that's the reason we're just very early, and there hasn't been the opportunity for sort of big scale insolvency related stuff, or the litigious matters that make it to court, because going to court's really expensive. Yeah, I think it's undoubtedly gonna come.
So let's just talk about, relationship property law, which I know I come in knowing not much about relationship property. So I guess to those who are listening, what is the Property Relations Act, and why should we care about this act?
So look, in a nutshell, the Property Relationships Act is the governing statute here in our country in New Zealand, which classifies what is or is not relationship property, and how such property should be divided and when it should be divided and so on. So that's really why it's so important to all of us here. When a relationship comes to an end, the PRA, I'll just shorten that, sorry, if I can, abbreviate it, that's when the PRA comes into play for each and every one of us.
And when you talk about relationships, what kind of relationships are you meaning?
Yeah, and it's a great question, Sophie, because it's not just all relationships. It has to be a qualifying relationship. And so what I mean by that is under the statute, it makes very clear what relationships this Act applies to. So generally speaking, it's relationships of 3 years or more, in which case there is a presumption of equal sharing of relationship property. But if you have been in a relationship that's endured for less than 3 years, and that's named under the statute as a relationship of short duration, then the rules are a bit different. Where it's a marriage of short duration, there's a special procedure, essentially, that's provided, special rules. But where it's a de facto relationship and not a marriage, essentially the PRA will not apply unless there's quite a high threshold met, where the court will step in and apply the statute.
What kind of property, I know this might be a huge question to answer, but what kind of property can be disputed under the PRA?
So property under the PRA is any property which is personally owned as opposed to trust or company owned, which meets its definition under the Act. And it will apply to fixed property, such as land, situated in New Zealand, and also movable property, such as cash in a bank account, both in New Zealand or elsewhere overseas, in most cases where one party is domiciled in New Zealand or the parties have agreed for our country to have jurisdiction. But what is relationship property is, of course, an altogether different question. The relationship property susceptible for division under the Act is generally, in the absence of any applicable exceptions, all property that is acquired by either partner or spouse, or by them both jointly, during the course of their relationship, the proportion of the value of any insurance policies or KiwiSaver or super scheme attributable to the relationship, and any other property that the parties have otherwise agreed is to be or become relationship property under a formal agreement. I should also say that there are two types of property which are both given special status under the Act as being relationship property, irrespective of when or how they were acquired. And those are the family home, which is the property used by the parties as their sole or principal residence, and family chattels. On the other hand, separate property is negatively defined as all property which is not relationship property and will generally be property which predates the commencement of any qualifying relationship. However, again, there are exceptions and ways in which separate property can, wholly or in part, convert to relationship property. For example, when the property was acquired immediately prior to the relationship in contemplation of that relationship, and intended for the common use or benefit of those parties, or where the sustenance or increase in the value of separate property is attributable to the application of relationship property, and other such circumstances.
And so when we're talking about the PRA applying, do we mean it applies to everyone in every situation, or is there a contracting out? Is there a separate agreement that you can make before you get married? How does that work?
Yeah, that's exactly right. You're on the money there, Sophie. So basically, we have, and you've used the exact right term too, contracting out. A lot of people adopt the American term, a prenup, but that's our version as a contracting out agreement. And essentially what that does is it gives spouses and partners an opportunity to depart from whatever the Act provides and say, hey, look, we're not going to have this apply in our situation. We want to set our own rules for when our relationship comes to an end, whether that be by separation or by death. So on the assumption that any such agreement complies with the requirements under the Act, because it's not just any agreement, it needs to meet some rules, such as being certified by a lawyer and that sort of thing. And I can go into more detail about that if necessary, but there are some rules, and if the agreement, the contracting out agreement, meets those rules, then it will apply. And so that the Act is put to one side and the agreement comes into play. And
with property, it's obviously a very broad term, as you were talking about before. And with crypto being such a new asset that's kind of coming up and coming, and we know we've talked about Rusco and Cryptopia a couple of times today, which held that crypto as property under the Companies Act. Do you think that this would extend to the Property Relationships Act? And what about NFTs as well?
Yeah, so in my view, there's no doubt that it does. It sits really comfortably within the very wide, as you say, definition given to it. Not just, not in the context of the Companies Act, but also likewise in the PRA context. So I won't bore you with the exact definition, but it is really wide, and it certainly does capture digital assets such as crypto and NFTs.
To my knowledge, there are not yet any reported cases affirmatively or unequivocally confirming that all forms of crypto and NFTs are classifiable as property for the purposes of the PRA, though there is a case at the family court level by the name of Beck and Wilkerson. And in that case, while the court did not undertake any proper assessment of the position, it dealt with crypto known as Litecoin, like all other property in that case, seemingly without pause or question. As to whether it was relationship property in that case, the judge had commented that the particular crypto, Litecoins as I say, was obviously a relationship property asset, and that he accepted that the Litecoins were part of the property pool, and indeed went on to make relationship property orders in respect of that crypto.
So it seems that the lawyers in the case sort of accepted that it was property.
Yes, yeah. That's
Yeah.
right. James is absolutely right. It wasn't sort of didn't come up as a contentious issue, as it were. It wasn't something that was argued. It wasn't something that the judge was asked to make a determination on. It was just without question. The counsel and the judge went ahead and proceeded as if it was absolutely within that pool of property.
Can we just backtrack a little bit and explain Rusco versus Cryptopia? Because it might be like the Bible in legal world, but I don't know much about it.
Sure. So Rusco is the name of David Rusco, who's a insolvency practitioner, and Cryptopia was the cryptocurrency exchange that the liquidators were appointed to. The main issue in that case is the crypto which was on the exchange, was that trust property? So are the people who were using the exchange, was the crypto held on trust for them, or were they simply a creditor in the liquidation? And the reason why that's important is because if you are a trust creditor, then let's say you hold one Bitcoin, where you had one Bitcoin on the exchange, and there's one Bitcoin available. If you're a trust creditor, then you get that Bitcoin. Whereas if you're just a creditor in the liquidation, and there's only one Bitcoin to go around with 10 other creditors, then you only get a slice of the Bitcoin, right? So the outcome for you as a creditor can be wildly different. And I guess the really key thing, the reason why Rusco and Cryptopia is really important is because it was one of the first cases which decided that crypto could be property and could be the subject matter of a trust. That's why it's really significant for New Zealand law relating to crypto.
Yeah, that's interesting. And what year did this exactly happen? Was it how many years after Cryptopia? And how many years? So for something like FTX, how many years does it take for legal cases to come out and for them to be kind of solved in this current climate?
Yeah, so I think Cryptopia, don't quote me on this, I think it was went insolvent in 2019. I think the case was heard in 2020. So that's a reasonably quick resolution of
it was 2020, James.
That particular issue. There are other cases, for example, Mt. Gox, which is one of the biggest exchanges. It was the biggest exchange in the world, and that was a Japanese-based exchange that blew up in 2014. Subject to several hacks, and that matter has been ongoing. It's still going, and there has been a lot of litigation in relation to that matter. So creditors are still waiting to receive any distribution on that matter. So FTX is ginormous, right? It's significantly larger in dollar terms to Mt. Gox, and it's got very different issues to Mt. Gox. There's a lot of it's not just hacks, there's various other matters to consider. So, there's 130 plus companies that are in the FTX group that are affected by the insolvency. There's currently a jurisdictional battle going on between where is the best place for the insolvency to be dealt with, in the US or in the Bahamas. So I'm expecting FTX could last years before there's any resolution.
And with something like FTX, where there's millions of creditors, is it dealt with in a kind of class action type of way where all of the creditors take FTX to court as a collective, or can you as an individual take FTX to court to try and get back what you're owed?
Yeah, so we're typically the way that it works in New Zealand, I can't really comment on exactly how it's going to play out with FTX because that's a matter of foreign law. But in New Zealand, typically what happens in an insolvency is everyone will, the liquidator will get appointed, and they will call for creditor claims. They'll ask creditors to submit their claims, and they will assess those claims and quantify them, and then work to get the assets in to recover the assets. So there's a pool of assets, and then they will, like they did in Rusco and Cryptopia, seek directions from the court as to, in this case, there was a legal issue about how the funds were held. And so they sought directions from the court to be able to determine how that those claims are dealt with. So typically in an insolvency, you would need the consent. If you wanted to bring a claim, you would need the consent of the liquidator or the leave of the court to continue with the claim, to bring the claim and continue it. A lot of the time, there might not be any point for a creditor in bringing an action, unless the liquidator had rejected their claim or and they disagreed. But a lot of the time, the creditors will work with the liquidator to determine whether their claims are valid. And I know in the US, there's been talk of class actions potentially being brought by other promoters of FTX. I know Tom Brady and Larry David from Curb Your Enthusiasm and Seinfeld are potentially facing a class action over there. And that's, in that situation, what the creditors are doing, they've probably got claims in FTX, in the insolvency of FTX, but then they're also looking for other potential pockets of money to be able to get a recovery. And so they're looking to Tom Brady and Larry David as an alternative source to recover their loss.
Yeah, it's pretty crazy how kind of laissez-faire all of the celebrity endorsements of cryptos and exchanges has been over there. And I don't know, in some ways, personally, I think good on them for trying to get what they're owed, especially if they're kind of hoodwinked by some flashy celebrity smiles to buy some FTT.
I think the angle that they're taking over there with the class action is that there were unregistered securities which were being promoted by these celebrities, and because they were unregistered securities, they didn't have the proper disclosure as to the interest that those parties were receiving from doing their promotion. Kim Kardashian and Floyd Mayweather have, got themselves in similar hot water for their promotion of crypto projects. One was called Ethereum Max, and Kim K, she recently reached a settlement with the SEC, which is the US regulator. I guess you'd say our equivalent in New Zealand is the FMA, Financial Markets Authority. So yeah, there's on a big collapse like this, there will be a lot of litigation, multiple parties, and it could take years.
Let's say that someone in New Zealand has some kind of relationship with FTX, or they were someone in New Zealand wants to sue FTX. How does that work? Because crypto is so global. Like, how can you do international lawsuits?
Yeah.
And what would you advise to a client?
It's a really good question, Nikita, because, I mean, there's this perception that crypto is always decentralized, right? Bitcoin's a great example. There's no CEO, there's no board of directors, there's no registered office. They're not located anywhere, right? Because it's a network of computers. Whereas something like FTX, that is what I'd call a centralized entity. It is a business that deals in decentralized assets. So they can be located or headquartered in a particular place around the world. That's where the business is operated. In FTX's case, it had its head office was apparently in the Bahamas, and but there was also there are other offices within the group that might be headquartered, for example, in the US or in New Zealand, or other places. I don't think there was an FTX in New Zealand, but so that's where, because there is this on-ramp, off-ramp scenario with crypto, where you still, if you want to own crypto, generally you have to use an on-ramp like an exchange. In New Zealand, we've got exchanges that you can use, like Dasset, or there's converting places like Easy Crypto that'll turn your New Zealand dollars into crypto. So there's this on-ramp, off-ramp, and those tend to be in a country where you can bring a cause of action against the place where that business is located.
I see. And when you're suing from a different country, is the process like if someone from New Zealand's trying to sue FTX, do they apply the New Zealand law or the law of where the exchange was located?
Yeah, it's an interesting question. The answer probably turns on the terms of use of the exchange. Often those will dictate a jurisdiction where the parties are permitted to bring their legal claims. There can be arguments that the terms may not apply. For example, you could argue that your loss was suffered in New Zealand, so potentially you might have a cause of action that can be brought in New Zealand courts. In that event, if you were to bring the claim in New Zealand, but there were terms and conditions that said the proper jurisdiction was the USA or Singapore, then there would probably be an argument between the lawyers about which is the proper place to bring the claim. Yeah, in the FTX matter, there's an argument over whether it should be in the US or whether it should be in the Bahamas, and so I guess the way that depending on how that plays out, let's say it plays out and the courts determine that it's the US that's the proper place for the insolvency to be managed, then in that scenario, probably US law might apply, and you'd want to get advice from a US lawyer, right? But it could equally be the US courts are dealing with it, but they're applying Bahamas law. I don't know.
Do you ever see an international entity like the UN coming up for crypto-specific matters? Like, let's say in 50 years' time, do you see that as something that's feasible?
Or like having like a global type crypto court?
Yeah, like the International Human Rights Court, but like International Crypto Court.
Yeah, it's possible. I think in the immediate term, typically lawyers will draft terms that suit their the parties who they're acting for, right? So, and parties in business and crypto they'll forum shop, so they'll find the most favourable jurisdictions to do business in, right? There might be reasons you want to do business in New Zealand because we've got a reliable and trustworthy justice system, whereas you might not want to do your business in another country where there's maybe more authoritarian governments and less trust in the legal framework. But typically lawyers will draft terms so that the most favourable legal jurisdiction applies, right? So if you're a New Zealand business, a lot of the time you don't want to have to go to a different country to argue your case. You'd want to argue it at home. So the business would probably want a New Zealand jurisdiction clause in their terms of use.
I'll let Sophie go back to the relationship law. Sorry.
It's a bit of a tangent, but it's very interesting to hear about what might happen with FTX. So when we're dealing with crypto and relationship property, are there any issues that are unique to that space, or do you think crypto as property would be dealt kind of similarly to money or other kind of assets?
I wouldn't say it's unique, unfortunately, but I would say that it emerges as a really difficult issue is the issue of disclosure or discovery if it's in a formal context. So what I mean by that is the provision of information from one former spouse or partner to another to identify what property is in existence so that it can be then, classified as either relationship property or not, valued, divided, and so on and so forth. So why this is such an issue in the sort of digital asset space is because, and in particular with crypto, because there are so many different types and, some are regulated, some are not, they're held in different ways, et cetera, different places. This can inevitably cause some pretty significant complications for someone who is trying to identify what the relationship property pool is. So if you think about it like real estate or shares in companies, for example, they have centralised services or systems like the likes of LINS or the companies register or what have you, where you can search by people's names. So, you can search under the name of your former spouse or partner to see what is held. It's not that easy, of course, when it comes to, digital assets like crypto. So if you don't know that crypto exists, or it exists but you don't know to what extent it exists, so the size of the holding, in other words, it makes it very difficult to identify that if the other party isn't forthcoming about that information. So because of the anonymity that's offered by this space and the intangible nature of these sorts of assets, it can be very difficult for people to get to the bottom of this, especially people who, and I come across this invariably with a lot of women coming out of relationships where people haven't been across the finances or property affairs during their relationship. They've been excluded from those matters. It makes it very difficult for them to know what there is, and as I say, what the extent of it is. So suffice to say, there's an abundance of opportunity here in this area for one spouse or partner to hold assets without the knowledge of the other person, and to choose to be pretty exclusionary about it, and to conceal those assets to put them into a more favourable position.
Yeah, all good points, Kez. Yeah, totally agree about the anonymity point. And another point to know is that there's thousands of these things, right? I think if you go into CoinGecko, there's like more than 10,000 different altcoins. That probably doesn't even include NFTs, the various collections of NFTs, which has gone bananas. So there's, it could be, what's a good analogy? It's not like in the old days we used to have channels 1, 2, and 3, and you'd know that there was, 3 channels around. It's not just Bitcoin and Ethereum anymore. It's like when you go onto Netflix or Disney or something, there's just thousands of shows. So knowing where they might be located, and what app they could be located, on what device can be very, very challenging. And I guess another sort of more nuanced point that in the Beck and Wilkinson case, everyone assumed that Litecoin was relationship property. That doesn't, while Kesia's absolutely right, I think there's really strong arguments why most crypto will be covered by the Property Relationships Act. We don't know for certain, right? There's someone could make the argument that James coin is not a relationship property, and then there might have to be an argument over it, right? There's still a lot of grey area around whether NFTs are relationship property. So there was a case, I think it was maybe UK, called Wang and Darby, which was about whether crypto could be, I think it was Tezos in that case, could be property subject of a trust, and the court made some remarks that suggested that NFTs could fall within property that could be subject matter of a trust. So, I think there's a good argument that if fungible tokens like Bitcoin and Ethereum, which means that they're interchangeable, more like a currency, if they can be property, then unique assets, NFTs, which are one of a kind, then I think it's certainly arguable that they could be relationship property as well. But until we have cases that say yes, they are, there's still that grey area, and that could be litigated, right?
Yeah, and I agree with James. And, while I say that I express quite forthrightly and firmly, my view, it's without doubt that it would fall within the definition of property. And there's a lot of sources, while there might not be case law sources, there's a lot of sources that endorse that view. Of course, almost everything in law is arguable. A lot of the time there's not a straight answer on things. And, when things are argued, that leads to precedent, which leads to certainty. So certainly if there was, a case that, as I was saying earlier, effectively made the point, that would be of great assistance to clients, but also to lawyers advising clients. So, so that would be helpful. The other thing I just wanted to add as well in response to that particular question, Sophie, was I made it sound a little bit gloomy before about disclosure. And, it can be obviously very complicated and difficult in any relationship property case, but as I say, in particular in this space, because there's just such fertile ground for concealment, there are a whole lot of remedies, at your disposal that, where you can try to get to the bottom of this. So it's not all, doom and gloom, as I say. There's a process for these things, how these things work, disclosure or discovery in a formal context, as it's called. Where, first and foremost, the disclosure side of things in a negotiation context, you of course ask for full and frank disclosure of all assets held, or assets in which the other party has an interest. And you start there. And if you don't get anywhere with that, and there is some suspicion that there is some digital assets like crypto in existence, or the extent of those assets are not being wholly disclosed, that's when you can escalate it to other options, other more formal options, whether it be through the court process or otherwise. So there are definitely ways and means of, getting to the bottom of what is in existence. And James is a really awesome person to talk to about that, of course, having them himself, but also being involved, in it from a professional point of view, so personally and professionally, because he knows how all these things move and how they are held. And so he has indeed taught me a lot about where to look, which has been enormously helpful. But one of the starting points is almost always, looking at bank transactions, seeing how and when particular assets were acquired. If there's something there that cannot be easily or readily explained, what was that? Was that, one of these types of assets, or indeed another asset that hasn't been disclosed? With some of these digital assets, of course, if there's holdings on the blockchain, it might be even, for example, if someone has been forthcoming, you need to independently substantiate or verify what they're saying. Sometimes someone's word in the context of a separation, sadly, isn't enough. And you do need that verification, that independent verification. So, you can go to them and say, hey, look, can you, send me these transactions, records of activity, etc., of, your crypto holdings, and they can then access that information from a platform. If it is the type of asset, of course, that's, regulated in that form, and provide that to you to, as I say, show what's in existence or verify what's in existence. So there's a whole lot of things you can do. And then if you do go down the more formal route, there's options available to you, such as, making an application for discovery order, asking the other party to produce documents, and things like that, that's sort of getting a bit technical, so I can go into more detail about that. But, there are a whole lot of other opportunities that you can sort of use and court process that you can activate. But the other one is, of course, with a lot of these digital assets, if they are held by an exchange, then there's, I'm sure you ladies will be well aware by now, but there's applications, mobile applications that will be used to access, accounts and things. And so it might be that you're simply asking the other party to, provide information as to those applications on your phone. So, on the other person's, phone. So you have to think a little bit laterally as well. It's not sort of a straightforward one. You have to sort of, think about other ways and means to get to the bottom of what's going on here when it comes to these sorts of assets.
Yeah, all good points, Kez. And having someone who understands the stuff and how it works and the different ways that it can be acquired and moved around is probably invaluable in this area, because, someone who deals with crypto will know if you are acquiring, moving money from your bank account and that's going to Easy Crypto, you'll know that that person's probably got an account with Easy Crypto, and you'll know that Easy Crypto will probably send the account holder an email specifying their transaction or giving details of their transaction. There'll be a log that has their transaction history, and you'll be able to identify at least certain purchases that you can ask questions. It can lead you down a path of inquiry, and also there's increasingly in this space parties that specialize in crypto blockchain forensics, right? That can help you to recover funds. I mean, FTX is a great example. There's a really well-known outfit called Chainalysis that is currently working with I understand Chainalysis is actually a creditor of FTX as well for the services that it provided to FTX. But they're helping because there's been some money moving around. They're helping to locate where it's going, and if they understand where it's going or which wallets it's hit, potentially then if it's a wallet with another exchange, for example, then the parties involved might be able to get, for example, a freezing order in respect of the party that manages that other exchange, right, to try and stop the flow of the funds and the movement of the crypto. I guess that's part of the beauty of crypto. It's built for anonymity and privacy. That's where the name crypto comes from, cryptography, right? But at the same time, the blockchain is very transparent, so it can be followed, and ultimately that can lead to recoveries. It might take a while, but yeah.
Exactly right. It's what to ask. And James is absolutely right. This is why it's so important to have someone like himself, that knows, how things move, where they go, how it all works. Not just what to ask, but, why to ask it. Those are really important as lawyers to know. So you're not just going on and indeed you shouldn't, some sort of fishing expedition and, sort of flying blind. You need to be putting really targeted and specific questions to the other person, whether it's them directly if they're unrepresented or their lawyer, to really get to the bottom of these things. The other thing I was going to say was I don't want to neglect NFTs here. NFTs also, they often they are launched on, the likes of Twitter, as James was mentioning earlier, and that sort of stuff. And so those really, big, giant platforms. So if there's some suspicion that there's an NFT has been acquired by the other party and it's not necessarily being disclosed, it could be that you review those platforms for their user engagement and see whether or not there's any helpful information that can be derived from there. But it's still tricky. And the other thing also, I suppose, is, and I remember saying this to you, James, I don't know if you remember a while ago, it would be very uncommon, nowadays, but what if these sorts of assets are acquired using cash? That really puts you in a difficult spot. As I say, it's not going to be common because not a lot of things are acquired using cash these days, but it may be that, these sorts of assets, depending on what they are, how they're held, all of those questions can never be identified. Or indeed where you have, and so I'm just thinking out loud here because I'm thinking about Beck and Wilkinson, which James and I have talked about a couple of times already. In that case, they had this sort of asset held on a phone, which from memory, I think the case was that the phone had been lost or had been removed from the phone. I can't quite remember the exact details, but once you lose the details of these sorts of assets, then it's completely lost. And that's something that's always been, was sort of quite alarming to me when I started to learn about these sorts of assets was, if you lose that really important information, you lose the asset entirely. Do you remember, James, we used to talk about that, didn't we? About, it's quite scary, really. If you're putting, as particularly, of course, if you think where there's a large volume you've put into this and you've acquired it for quite a significant sum, and you lose the key or, what have you. Yeah,
I was a little skeptical about that. It's on my phone, I can't access it for the most part unless you've lost the seed phrase or the private key. You can usually spin up whatever the wallet was before on a different device, right? If I had...
Well, I had one. Yeah, and all the judge could do then in those circumstances, of course, was to say, look, it is define it as relationship property and say if and when it is found, it's to be divided equally. So put the judge in a very difficult spot about quite a difficult technical issue. So, yeah, quite tricky.
Here's an example, right? If I am out at the pub and I leave my phone there and if I was concerned, the phone's gone. If I knew the app which I was using, the software wallet that I was using, use one like Exodus, for example. If I know my seed phrase, then I should be able to download the Exodus app again, put in my seed phrase, and bang, there's my wallet, right? It's available because it's there on the blockchain. You just need to have the private key to be able to access it. And it's a totally different story if you've lost the private key, then you're stuffed. And that's why there is, I guess, this tension between some people like to hold their coins on a exchange where the wallet is managed by someone else. You have a different type of risk doing that to the risk of you holding the coins in self-custody or, in a cold wallet.
I have two questions from this. So what happens if there's someone in a normal boyfriend, girlfriend, husband, wife relationship, and one of them tells the judge or someone that they lost the crypto key, but in reality they haven't, and they're just trying to keep the crypto to themselves. And my second question is, how many cases are you seeing where this is becoming an issue in your law practices?
In terms of they're both great questions. In terms of your first question, look, the reality is that the judge or the court has specific powers, and one of those powers isn't to reach into the personal lives of these people and do anything more than they're able to do or empowered to do, as I say, under statute. So if they're told by the other person, the other party, who may or may not be holding crypto they haven't disclosed, or their lawyer, that they don't hold the crypto, or that what is held is what has been disclosed and nothing more. That goes to the extent part that I'm talking about, the extent of what this asset is. There's not too much more that the judge, too much further that the judge can take that. All that can be done really, as I say, is these other tools can be used to try and get to the bottom of it, and it's for the party who's wanting to find out about the crypto, them or their lawyer, to activate those processes to get to the bottom of those things. And as I said, I don't want to get too technical, but there are quite a lot of ways and means that you can do that. But the most sort of common or obvious, of course, is making an application for discovery and asking really targeted and specific questions. Your second question, the answer is absolutely yes, we are. And I may not necessarily say we are. I am. I can only speak to my own practice personally. I see this a lot, and James knows because I've had to call upon him a couple of times. But I do come across this quite a lot now because, of course, as this space becomes more popular and commonplace, a commonplace way of people acquiring assets, and people are, I think, over time becoming more and more interested in diversifying, their asset portfolio, and so they're looking to new and interesting things like this. Then I do, as a family lawyer, I am increasingly acutely aware that these assets might be in existence, and so I sort of have a checklist, if you like, of assets that, when I'm talking to someone who's wanting to divide their relationship property at the end of a relationship, assets that I ask them about, do you have, what sort of real estate do you have, how is it held, when did you acquire, etc., etc. When I go through that sort of mental checklist, I now have added essentially, digital assets, and in particular crypto and NFTs, and more the response is yes, we do, or he does, or and so you do need to come up with some interesting ways too, as I've talked about earlier, to try and get to the bottom of exactly what it is.
Yeah, totally right. Yeah, we've and also clients who are interested in estate planning for their. I've got one client who's elderly. He's looking to pass on, is ill, looking to pass on his crypto, make sure that it's done in a way where the crypto isn't lost, right? So that can be quite challenging. There's a lot of moving parts in there. It's not. It's because it is so easy to move significant sums of money so fast, and you have to be constantly aware of the security risk. There's a lot of things to consider in that space.
And I suppose the person receiving it would have to then learn how to handle crypto as well, which is not something you don't really have to teach someone how to hold a house or bank account.
That's exactly right.
Kez, maybe you want to have a talk about some of the options for, if there is crypto as relationship property, how it can be dealt with in terms of a separation division.
Yeah, look, I think that's a superb segue. Thanks, James. Because that's exactly right, Nikita. What you've said is absolutely right. That will necessarily inform what the best or most desirable way of handling these assets in a separation should eventuate. Because some options, of course, where there's a party that's not interested in holding the crypto, just frankly and bluntly, just simply is not interested or hasn't been involved in the acquisition or management of that asset, and has no desire to learn how to do that, and things like that. Those will all, as I say, inform or guide you to what is the best solution for your client as a family lawyer. So generally speaking, broadly speaking, there's three ways that you might want to look into to distribute these sorts of assets on the end of at the end of a relationship. And perhaps the most obvious is for the crypto or the NFTs to be liquidated and for the proceeds to be divided equally between the parties. And you just need to be aware, I think, as a family lawyer and as a person who, this is impacting, that there might be tax implications of that. So, but that's sort of the most, I would say probably common, but the most obvious option. Another option is for one party to keep some or all of the crypto or NFTs, and to compensate the other person for the value of that. So where one party has been the one to acquire the assets, like I say, it might be a sensible option, that they continue to retain the asset, and if the value can be agreed between the parties, that, the other party is then compensated sufficiently for that. And then the sort of third most common, I would say, option would be that the crypto or NFTs are kept in their current form, so as digital assets, by both of the parties, but shared equally between them. So this would be, unlike the sort of situation I was talking about before, this would be in a situation where actually both parties are interested in, this digital asset space, and in particular in crypto, let's say, and they have they're interested, they're keen to continue to hold the asset, and know how to manage it and all that sort of stuff. This might be something that speaks to them, that they would actually both want to keep it, but they want to split it up between them. But of course, you then need to think about, well, do they both have accounts, or can they both hold the asset? Do they each need to create an account or what have you? Do they need to set up in a wallet? That sort of thing. So, it might be that they just want to split it, and then, of course, in that option, you don't need to worry about the question of value, because it just is what it is, because they're each walking away with 50% of whatever it is. So those are sort of, as I say, broadly speaking, what the options would be.
Yeah, I guess you also have to understand your client's appetite for risk and volatility,
Exactly.
And that's not necessarily something that a lawyer can give financial advice on.
No.
But it is something that we have to be aware, because, I've just got up the chart for Solana, which is one of the they've got the Sol token, which is a currency, a cryptocurrency used in the Solana blockchain. That's down 93.4% for the year. And it's up in the last 24 hours, it's 17.8%. Right. So it's all over the show. I think previously it was up a lot more than 100%, at the top of the bull market in 2021. But, if your client has no idea about the volatility of these assets, then they could find themselves, just out at sea without a paddle or a life jacket, right? They could very easily lose their keys or their passwords and things like that, and next minute the crypto that they agreed to take is worth zero, and the crypto that their partner took is up 1,000x. It's there's a lot to think about.
And obviously, it's so true. So much crypto is so volatile, particularly at the moment. So in the second option, where one partner keeps the crypto asset and the other one, I suppose, gets a cash out, how would you go about valuing the property? At what point do you take the value?
Yeah, so another really great question, and I would say it's the other the second sort of key issue that I come across as a family lawyer when I'm dealing with this sort of asset, it's the disclosure side, like I say, that can be complicated, but also the valuation side can become a little bit tricky, and it's not just how to value it that's tricky, but also when to value it. Can be the subject of discussion and argument. So, because this is such a moving target, that the value of these assets, and it can change literally within minutes, it makes it very difficult to pinpoint at times, the value of crypto or an NFT. And as James was saying, I can't quite recall about what exactly, but as he was saying earlier about, lawyers really have to decide what is most favourable to their client when they're making their arguments. The same applies here. When you take the value of the asset and how you do that, what's most desirable in terms of the answers to those two questions will, of course, naturally, depend on who you're acting for. Okay, so what's going to benefit them most? So, for example, let's say you've got the client that is holding the crypto asset and it is, skyrocketing in value at that particular time where you're dividing the property. That's, you need to be thinking carefully about, how and when the value is attributed, what best suits them. It's going to be quite different, of course, for the person who's not to retain it. So from a legal perspective, the PRA, the Property Relationships Act, gives us a general rule about when property is to be valued. So this is the timing, when it's to be valued. And it says that it's to be at the date of hearing of any application. But of course, sometimes you're not in a proceedings context, in a formal litigation context. And so where you're negotiating rather than, having embarked on litigation, it will be the current market value. So what is it as at today's date? Again, there's been no reported cases that I'm aware of anyway in New Zealand which have determined affirmatively the time at which crypto or NFTs should be determined, but that rule in the PRA is really what we need to go by. From a practical sort of point of view, valuing listed tokens, for example, are pretty easy. It's not necessary for you, unlike other assets, to get some sort of formal valuation. So, for example, if you're valuing real estate, getting a registered valuation from a property valuer and those sorts of things. Because information is publicly available, you can get to a value quite easily sometimes in respect of these sorts of assets. And there are examples of sites, and James will know a lot more about this than me, but the ones I'm sort of aware of are things like CoinGecko or CoinMarketCap. Those are some examples of sites that track market prices that could be used. But in terms of NFTs, I remember James and I having quite a intense discussion about this. It is really tricky how to determine the value of an NFT. And as I understand it, how rare an NFT is directly linked to what its value is. So in other words, the rarer it is, the more valuable it is, generally speaking. So determining its rarity will be key in determining what its value is. So there are some websites that can assist you with this. James, will naturally be far more aware than me of, what the best ones are. But one thing I have learned from James is that you've got to be quite careful about the floor price, as they call them, on these marketplaces, because as I understand it, there can be different floor prices in different spaces. Is that right, James?
Yeah, totally. So the floor price is typically the cheapest asset up for sale, right? So that's not necessarily the least rare, although it could be. It might be someone who just needs to sell their asset. It might be really highly ranked, and they just need to liquidate it. They need to sell it, so they could be selling. They could set the floor lower, right? Because they want to get rid of the asset.
Yeah.
But the floor is usually a good guide, but that doesn't necessarily mean that's the value of the particular NFT that the client is holding. Yeah, and there's a whole bunch of things. What's the who's the party behind the token? If it's a recognized developer, like in New Zealand, Non-Fungible Labs is one of the more recognised developers. They're well known, and so possibly a token that they've produced might hold more value because they're likely to do a different project where value could accrue to the original NFT, you know. So yeah, there's a lot to consider, and it really helps to have someone who's familiar with that particular market, as well as challenging as that might be. I guess you also have to give some consideration here to, you know, it's very easy to spend a lot of money on lawyers trying to work out what the value of something is, and, you know, the value might not actually be that high. Someone came to us recently, and, you know, their partner was trading futures contracts, so they didn't actually own the digital asset, just trading a derivative, but the sums in issue weren't enormous, right? So you could spend an enormous amount of money trying to work out what these things are and how they should be divided up and at what value, and the cost of that could potentially outweigh the actual value of the assets in issue. So you've got to be mindful of that as well.
It's been very interesting hearing about how complicated it can be, and it's interesting to know how an NFT is so different to crypto assets, and I suppose that's a really good thing to keep in mind. Unless you have any more questions, Nikita, I was thinking we could roll through to our final 5 questions.
Well, thinking maybe final 6, because we skipped an interesting one I wanted to ask.
Okay, go ahead with that one then.
Well, a lot of our listeners are in their 20s, and I was wondering, like, what do you wish you had studied or worked differently back in your 20s?
From a law perspective, or?
Yeah, from a law perspective. Actually, a lot of our listeners aren't computer scientists. They're more like law.
So I studied fine art for a couple of years, and I was a painting major, and then I decided that there weren't enough rules in that space, so I decided to be a lawyer. Now I guess I find a lot of enjoyment in that NFT space because it is part of the art world. It's just an interest to me there. I guess my, it's, if you find something that you're passionate about and you think about it all the time, then you're more likely, I guess, to become a subject matter expert in that area, and then that will help you progress in your career, right? It can be a real challenge when you're a young lawyer and you're learning the different types of law. You don't know what one you like, and depending on where you work, you might learn a particular type of law. I didn't come out of law school thinking I was going to be an insolvency lawyer, but because I was in the insolvency team at the firm I was at, around the time of the global financial crisis, that's an area that I just naturally was doing quite a lot of work in, and so I have developed a specialty in that area. But my obsession with crypto assets has led me to develop, expertise in this area, and it's the sort of work that I love doing. I love working with Web3 companies who are building exciting stuff, and equally, I like helping people solve their problems if something's gone awry. So, yeah, try and find out something that you're passionate about, and push that.
Yeah, look, I would absolutely echo everything James has said. Really fundamentally what I'd say is, find something that you are genuinely interested and passionate about, because ordinarily the other good stuff will flow from that. If you're really passionate about something and interested, you'll put the time into it. You'll invest the time into it, and you will, be good at it. Like quite often, because you are putting the time in, and as I say, you've got a genuine enthusiasm for it. So that would be sort of my fundamental, tip to people who are thinking, which area of law should I get into, or just more generally, what should I do with myself from a career perspective? For me personally, it's always been, I'm very interested in people just generally, but in particular helping people. And so I find that through my work, I'm able to help people, and I do enjoy a challenge, and it is certainly a challenging space to work in. As we talked about earlier, a lot is arguable, and I do not like to be defeated, and that motivates me to, really come up with some interesting and unique arguments. And, if you like that sort of thing and you like a challenge, as I say, law is a really good option. And in particular, I find, that I do meet those objectives in family law. So yeah.
Yeah, and don't be afraid to fail. You give it a crack, and what's the worst thing that can happen? You have to try again. Could go bananas.
Yeah, it's especially relevant for females because we don't like to fail.
Very stubborn. So our final 5, and I think that we're going to start asking these questions to everyone that we have on. So you guys are the first, setting the ball mark, setting the mark here. So our first question is: are you camp Bitcoin or Ethereum?
I'm going to say both. Is it?
Both?
Am I allowed to say both? I'm bullish on both. Yeah.
Sure.
Well, I think Bitcoin is super important as an internet money, and it's very unique because it's decentralized, but a lot more decentralized than other protocols. It's really secure. Ethereum is really exciting because of what can be built on it, and it's just a different platform to Bitcoin, right? Different protocol. They both have their pros and cons, but I think. I really see value in both.
Yeah, absolutely. How about you, Kesia?
Quite honestly, James is far better positioned to express any sort of view on this. I'm going to say Ethereum, just because Bitcoin to me seems, it's been around, longer, and it feels a bit more boring. So for that reason alone, I'm going to go with Ethereum. So, really great advice there.
There you go.
Don't make any investment based on that.
Not financial advice.
Yeah, it's all right. We've got a disclaimer running at the end.
Yeah, I was just going to say, make sure this is accompanied by a very carefully worded disclaimer.
Yeah. Absolutely. They're just fun questions.
Well, that's how I treat Sophie.
So the next question, which might reveal a bit more about how much you really do like Bitcoin or Ethereum, is are you camp proof of work or proof of stake?
Yes, I'll leave it entirely to James. Yeah.
I actually see a lot of value in proof of work protocols. I think there's a lot to be said for the security of a network that's built on proof of work. Proof of stake certainly has its benefits. I think there's a lot of misinformation about energy usage and proof of work protocols using a lot of energy and that being bad for the environment versus proof of stake. Proof of work, just because if you have a Tesla, that doesn't necessarily mean that it's a clean Tesla if it's being powered by electricity from a fossil fuel plant, right? But if it is being powered by sustainable renewable energy, hydroelectric, geothermic energy or something like that, then it can be a much cleaner Tesla, I guess, right? And the same applies to the computers that are powering these networks. proof of stake just from a straight energy usage point is probably better, but I think there's a lot of risk in terms of centralization with proof of stake, which is harder to harder is probably not the right word, but which is maybe less prevalent with proof of work systems. I mean, again, it just depends. Each network is different, and some proof of work networks can be very centralized in terms of who owns all the rigs, right, and how young they are, where they're located.
Yeah. Cool. Not financial advice. What is the bold prediction for the price of Bitcoin over the next 5 years, or in the next 5 years?
A lot of this, as you'll probably have seen, is dependent on the global macroeconomy. So you will have seen in March 2020, when COVID hit, it looked like that we were going to have financial Armageddon, and the markets dropped significantly. But then the way that the central banks and governments responded with monetary and fiscal policy, there's a big flood of money into the system, and that money has to find a place to go. And a lot of the time it found its way into real property, stock market, financial assets. Crypto was a huge, benefited hugely from that, because there was, people hunting yield. The money got pushed into, I guess, riskier assets. So the opposite happens when the central banks want to take the money out of the system, for example, to cool inflation. We've got a cost of living crisis. Effectively, there is too much money floating around, so the cost of goods goes up. And now the central banks are trying to unwind that. They hike the interest rates and things like that. So that leads to a big cooling in the market. So who knows where we're going to be in 5 years. But one sort of metric that I look at for crypto is I look at what are other asset classes and what is the sort of share of asset classes that crypto could take, right? So there's something like 400 trillion total accessible market for all assets in the world. Don't quote me on that. Gold is around 10 trillion, something like that. Crypto at one point got close to 3 trillion. Bitcoin was like 1.3 trillion. It's now shrunk massively. Bitcoin is something like, I think, around 320 billion at the moment. If you assume something like gold is $10 trillion asset class, that's all the gold in the world's worth 10 trillion, and all the Bitcoin in the world, which Bitcoin, the digital gold, is worth 300 billion. If Bitcoin was to take 2% of the gold market, 2 trillion, that's 6x from where we are here. So that would, Bitcoin's today about 26,000 Kiwi. That might put us up around 160,000 Kiwi, right? Just on that sort of metric. But it's the markets are quite manipulated, and so it's really hard to know exactly where it'll be. But yeah, I mean, long term, I'm bullish.
Okay. Yeah, really long answer. The lawyer's answer.
Yeah.
So our next question is, what is something that you're really excited to see roll out in the blockchain space that's perhaps happening more in its kind of nascence at the moment?
Yeah, I think NFTs are pretty massive. There's so much that can be done with NFTs. They're not just 32-bit personal profile pictures of punks and monkeys. They are collections of bundles of contractual rights. You can have multiple different types of media on them: video, photo, pictures, audio files, whatever. So there's a whole heap of stuff that can go into them. It's pretty massive. Where I would personally really love to see more, something we talked about at the start, is for developing nations, the third world, more adoption of blockchain for example, digital identity, and also for property ownership, maybe even in real property, the real property space. So, I mean, there are people across the globe who have, they don't necessarily have a title to their property or their land, and if they have their identification documents confiscated from them, they've got no way of verifying their identity if they needed to escape that country for whatever reason, right? Yeah, the development of digital identity in a secure and private way is, I think, one of the big things that I'm looking forward to, an adoption of that more generally by governments around the world.
Good answer. Kesia?
Yeah, definitely support what James has said. And also just more generally, I think in the NFT space, I would really like to see, any and all, welcome any and all sort of developments in that area, because, it's just such a novel and interesting area. And, I feel like there is so much potential in that area for so much more to be done with NFTs. So I'm really interested to see what happens in the future with those.
Yeah, and it's only a matter of time before Kesia's blockchain avatar is, wearing some Prada heels, or
Well,
and she's wearing the real Prada heels in real life.
That's right. So very exciting times. I think I think it's just we're probably going to see so many interesting things come from NFTs. Yeah.
Yeah, start planning our metaverse avatars now to avoid disappointment.
Right.
Totally.
And our final question is, what are your guys' top tips for someone who wanted to get into and succeed in the legal profession?
I think we kind of covered this a little bit already. Find something that you're really interested and passionate about, and embrace it, write about it, talk to people about it. When you're interested in something, you will find a way to track down cases that are in different jurisdictions and learn about them. And that's my recommendation. And also speak to colleagues, learn from people who have done it. Law's a long career, and it's good to seek advice from older practitioners who've got a lot of life and law experience, right?
Absolutely. And so, welcome, invite and, really welcome, seize with both hands any opportunities to talk to anyone else about those areas of interest that you do select, areas of practice. And, be mindful that anyone and everyone, can teach you something, and different points of view can be explored and in a different way. So don't limit to your network or your opportunities to those that are internal to your practice, or your to your firm or your chambers or whatever. Really broaden those externally, and make use of any sort of networking opportunities to meet other people. And as I say, you'll almost always learn something from them and see things differently. So that something that you may think you want to adopt in your practice, or a really great argument in respect of some particular section where you just haven't really looked at it from that angle. So, yeah, and as James says, going back to what we said earlier, just the fundamental of being interested and passionate about what you're doing, and lots of other good stuff will flow from that usually.
And here's another top tip, but utilize technology, and the amount of resource that is available now, at your disposal. There's so much going on Twitter. There's, you can go on YouTube and you can watch current head of the SEC, Gary Gensler, when he was lecturing at MIT on crypto. You can watch 8 or 9 episodes on that platform. Get on an outrageously good podcast yourself, like Crypto Girls, and utilize that technology to connect and communicate with your network.
Yeah, absolutely. That's all awesome advice. Well, thank you so much for sitting down and chatting with us. It's been such a privilege to hear about what you guys do and to learn a bit more about relationship property. And we talked about FTX as well, which Nikita and I are obsessing over recently. But yeah, thank you so much.
But thank you guys so much for having us on. It's been great fun, and I'd be more than happy to come on again if you had any more questions.
I'm sure.
I'm sure we will.
Yeah. Don't say that. We'll call you for every bankruptcy.
Cool. Thanks, guys.
Thank you both for the opportunity. Cheers. Take care.
The information conveyed in this podcast is intended to be general, and any individual situation will turn on its own facts and requires professional advice. Investment in securities, cryptocurrencies, NFTs, and other asset classes involves risk, and no information in any episode of CryptoGirlsHQ is intended to constitute an investment recommendation. As such, this podcast should not be treated or relied upon as financial, investment, legal, accounting, tax, or any other professional advice, and is broadcasted for informational and educational purposes only. The views expressed by James and Kesia in this podcast represent their own views and are not necessarily endorsed by Lane Neve or Stace Hammond. In the interest of disclosure, the participants in this podcast, including Crypto Girls, hold various crypto assets across a range of platforms, some of which are mentioned in this podcast.